Welcome to our deep dive on the harsh realities of spousal immigration in the United States. Today we will discuss why urgency often collides with bureaucracy, what pathways actually exist for a U.S. citizen's spouse, and how factors like visa type and income shape your options. We will also cover risks around misrepresentation, compare consular processing with adjustment of status, and outline the financial requirements, including joint sponsors. Throughout, we will use visuals and quizzes to keep you engaged, and we will end with a concise action plan. This presentation provides general educational information and is not legal advice. Immigration outcomes depend on individual facts, and policies can change. You should consult a licensed immigration attorney before taking action. In this agenda, we will begin with a reality check on timelines, then transition to assessing visa risks with special attention to C1/D. Next, we will compare consular processing and adjustment of status, followed by a review of financial requirements, including the affidavit of support and joint sponsors. Afterward, we will describe an action plan with realistic timelines, include a couple of quizzes, and conclude with key takeaways. First, it is essential to recognize that family urgency rarely accelerates the immigration process. Unexpected life events, such as pregnancy, typically do not qualify for expedited handling. Therefore, immigration should be approached as a long-term process measured in years rather than months. Moreover, legal errors can be costly, including denials and potential permanent bars, which underscores the importance of careful planning and professional guidance. This flowchart illustrates the core decision logic. We begin by determining whether the foreign spouse is currently in the United States. If not, the path generally leads to consular processing. If the spouse is present in the United States, we then evaluate the visa category. For C1/D or similar restrictive categories, attempting adjustment of status carries a significant misrepresentation risk, often making consular processing the safer route. For other categories, adjustment of status may be possible but must be evaluated with an attorney. In both consular processing and adjustment of status branches, we check financial eligibility via Form I-864. If the income threshold is met, the process continues. If not, the couple must secure a joint sponsor, or the case may stall. The diagram notes approximate timelines. Consular processing can take 12 to 24 months or more, while adjustment of status may take 6 to 12 months, with potential work authorization around 3 to 6 months after filing. On the left, consular processing is typically the safest option for restrictive visas, such as C1/D, because it avoids many misrepresentation issues. However, it can take a long time, often 12 to 24 months or more, and the spouse must remain abroad until the visa is issued. On the right, adjustment of status can be faster and allows couples to remain together during the case, but it is risky or not viable for categories like C1/D due to intent problems. It requires careful legal evaluation to prevent potential bars. Next, we focus on the C1/D visa. This visa is designed for transit and crew duties, not for entering with the intent to apply for permanent residences. Attempting to use it to pursue adjustment of status can be deemed misrepresentation of intent. Consequences include denial of the application and possible removal proceedings. Because of these risks, consulting an experienced immigration attorney is critical before taking any steps. Here is a practical sequence. First, assess the current visa type and any prior entries or overstays. Second, consult a qualified immigration attorney to evaluate risks and options. Third, choose between consular processing and adjustment of status based on legal risk rather than speed. Fourth, confirm whether the petitioner meets the Form I-864 income requirement, and if not, identify a joint sponsor. Fifth, assemble comprehensive evidence of a genuine marriage and compile identity and status documentation. Sixth, set realistic expectations that timelines may span years. Finally, avoid misrepresentation at all costs. Do not conceal intent or material facts. This timeline contrasts the two pathways. Consular processing typically spans from the I-130 filing to National Visa Center processing, and then a consular interview, often totaling 12 to 24 months or more before visa issuance. Adjustment of status starts with concurrently filing the I-130 and I-485. Followed by biometrics and potential interim work and travel authorization in roughly 2 to 6 months, and an interview or decision around 6 to 12 months or longer. The actual durations vary by location, caseload, and policy changes. This mind map centers on Form I-864, the Affidavit of Support. One branch explains the income threshold at 125% of the federal poverty guidelines, adjusted for household size. Another outlines the petitioner's legal responsibility to support the immigrant and potential reimbursement obligations for means-tested benefits. The joint sponsor branch describes who qualifies U.S. citizens or lawful permanent residents domiciled in the United States, and how the obligation generally lasts until the immigrant becomes a citizen or accrues 40 quarters of work. Additional branches list evidence such as tax returns, W-2s, pay stubs, and employment letters, and note that without meeting the income requirement or obtaining a joint sponsor, a case can stall or be denied. This table summarizes the essential points of the Affidavit of Support. The threshold is based on 125% of the federal poverty guidelines for the applicable household size. The petitioner must sign, and if the petitioner's income is insufficient, a joint sponsor may be added. The obligation generally ends when the immigrant becomes a citizen or accumulates 40 qualifying work quarters. Evidence typically includes recent tax returns, wage statements, pay stubs, and employment verification. If income falls short, the couple must secure a qualified joint sponsor or face delays or denial. Here's a concise recap formatted in Markdown. The key truths are that speed is not an option, adjustment of status with a C1/D visa is high risk, and meeting the I-864 income requirement is non-negotiable. The safe mindset is to plan for a marathon, maintain strong documentation, consult an attorney, and avoid misrepresentation. For choosing a path, consular processing is typically safer but slow, while adjustment of status may be faster but is risky or unavailable for certain visas. Quiz question. If a spouse enters on a C1/D visa, intending to immediately file for adjustment of status, what major risk does this raise? Options are A. Administrative closure, B. Misrepresentation of intent potentially leading to denial or removal, C. Automatic approval due to marriage to a U.S. citizen, and D. Only a minor processing delay. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Entering on a C1/D with the intent to adjust status can be treated as misrepresentation of intent, which risks denial of the application and possible removal proceedings. Quiz question. Which pathway is typically safer for spouses on restrictive visas such as C1/D? Options are A. Adjustment of status, B. Consular processing, C. Visa waiver program overstay, and D. Tourist visa with multiple entries. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Consular processing. Although it is slower, it is typically safer for restrictive visas because it avoids many of the intent issues that can jeopardize adjustment of status. Here are the key takeaways. Urgency rarely alters immigration timelines. Attempting adjustment of status from a C1/D visa is high risk. Consular processing is usually the safer long-term strategy. The I-864 income requirement must be satisfied, and if not, a qualified joint sponsor is needed. Finally, professional legal counsel is crucial for complex or risky cases. To summarize, start by assessing the current visa category honestly and as early as possible. Then, choose your route based on risk rather than speed. Ensure you meet financial requirements for the Affidavit of Support, or secure a joint sponsor. Set realistic expectations for multi-year timelines, and consult a qualified immigration attorney for tailored guidance. Thank you for watching. If you found this helpful, please like the video, share it with someone who needs it, and subscribe for more deep dives. We would love to hear your questions and experiences in the comments.